Did you know that you can actually copyright certain types of generative AI content? Maybe you've seen discussions online where people are saying that you can't actually copyright AI content. Did you ever want to use AI generated content but are not sure if you're protected legally? In this video, I'm going to show you how you can copyright and trademark AI generated content. At the end of the video, I will also go over where you can get away with using generated AI content and where you should definitely avoid it at all costs. Hi, I'm Radu Madan. I'm a designer and brand strategist. I help companies like yours successfully launch their brands and attract new clients. Since we're talking about copywriting AI, I figured the best place to ask if it's possible to copyright AI would be, of course, AI itself. So this is the prompt that I used. Hi chat, you're an expert in IP law, specifically copyright and trademark. I want you to answer the following questions. Can you copyright AI generated content, and can you trademark AI generated content? I also asked it to look at the difference between the US and the European Union and see if they're different or the same. This is the results that I came up with, and I also asked it for the sources, which we will be taking a look at. But first, let's have a look at what copyright is. Copyright is a type of intellectual property that gives its owner the exclusive legal right to copy, distribute, adapt, display, and perform a creative work, usually for a limited time. So that's the word that's important, creative work. What is a creative work? Creative work is a manifestation of creative effort in the world through a creative process involving one or more individuals. That's super key. The term includes fine artwork, sculptures, painting, drawings, etc., dance, writing, literature, filmmaking, and musical composition. Reason why I underline individuals is because it implies a human created the copyrighted work. With this in mind, let's look at the copyright protection when we're talking about AI. If it is pure AI content, the answer is no. You cannot copyright pure AI content as is generated by a machine by itself. For AI generated content to be copyrightable, there has to be some kind of human involvement. Otherwise, on its own, you cannot copyright that work. So there's a potential here that you can get it copyrighted. So let's have a look at the results that came up in our search. Let's look at the US. There is no protection if the work has no human authorship. Once again, that word, the individual, the human. Purely AI-generated outputs, no meaningful human contribution, are treated as public domain and cannot be copyrighted. In the EU, it's similar. Generally, there is no protection unless there is, once again, human creative contribution. Works created solely by AI without human creative input don't meet the originality standard. Originality is usually attributed to humans, so at this moment in time, we don't consider machines to have originality. Their output is generally on trained data, which was, of course, human created. Looking at the results, we can now have a look at a few websites. There's the copyright.gov, the US Copyright Office, where you can look at the report on copyright and artificial intelligence, which part 2 has a copyrightability portion where it will discuss what we just spoken about. For the EU, you have to look at the EU IPO Copyright Knowledge Center and the AI Act from the European Commission. These are the places where you will get your information in regards to it's possible to copyright works and under what conditions. So I definitely urge you to look at these two websites. Going back to our chart, we can now rule out pure AI copyright from being copyrighted. So now we have to answer the question if human involvement exists. In other words, how much have you input after you've created the work in AI for it to be copyrightable? Going back to our charts, in the US, you can partially copyright the human authored expressive elements. The selections, the arrangements, the modifications can qualify for copyright. The US copyright also requires disclosure of AI elements and will only register the human portion. You cannot copyright, however, the prompt. That's not, even though you came up with the prompt, that led to a result, and that result is not copyrightable. Once you get the output of the generative AI, then you can modify it, select it, cut it, and maybe that portion will have enough human input for it to be copyrightable, but not the prompt. Or at least to my knowledge, not at this moment. In the EU, it's similar. It's potentially, again, the human's intellectual creation is reflected in the work. Parameter choices, creative edits may meet the EU originality requirements. Okay, so here what they're essentially saying that perhaps the prompt may have some copyrightability. In my opinion, if it's just a prompt and the results are still machine generated, if you haven't gone in with enough modifications or changes, it's probably not going to be applicable. To get a little more clarity, I've pulled out the Schoner article right here, and I want to read the following. The implication that copyright must belong solely to individuals was reaffirmed in the Artificial Intelligence Strategy of 2023 issued by the Court of Justice of the EU, which excludes purely machine-generated content from copyright protection. So we have a situation where just the output you can't copyright. Arguments can therefore be made whether the prompt part is copyrightable, which is a little bit different from the US side of things if that's the case. Coming back to our chart, therefore, who can actually own the copyright on AI-generated content? In both cases, it's just the human. Right? US, only human-created contributions copyright. Prompts are generally not enough. And in the EU, must show the work reflects human intellectual effort under these specific laws. That kind of makes things pretty clear. You can't copyright AI if it's just machine generated. However, once you start to modify it, add your own creativity, if you will, to it, then maybe perhaps you have a way to copyright it. So let's look at an example. Say I generated this wonderful pastoral scene somewhere in the forest using AI. So what I prompted was I would like an AI, not an AI background, but I would like a forest background where only the nature is visible. I asked it to create it sort of in the style of a cartoon. Perhaps I want to use it in an animation or some other kind of project. This on its own, in my belief, you cannot copyright because you did not generate it. But say, for example, that I decided on a whim to add some forest creatures that I draw in myself. So I've added here a rabbit, you've got this deer, and off in the distance they're both looking at these backpackers that are getting hoovered up by our TR3B. In this case, does the work now become copyrightable? In my mind, yes, because I've added elements to the scene. I might still not be able to copyright the background, but the entire composition on its own now is eligible in the way that I see the things. So then I can make these characters animated on the background, and then I would have something that would therefore belong to me. Let's have a look now at trademark and how it differs from copyright. So first off, what is a trademark? Trademark is a form of intellectual property that consists of a word, phrase, symbol, design, or a combination that identifies a product or a service from a particular source and distinguishes it from another. The trademarks can also extend to non-traditional marks, drawings, symbols, 3D shapes, product designs, packaging, sounds, etc. Now the difference from copyright, which speaks to a creative work, function of a trademark is a little bit different. Okay, the primary function is to identify the source of goods or services and prevents consumers from confusing them with those from other sources. So here we have the primary difference. Copyright speaks to a creative work that maybe is an expression of an idea, all right, through sounds, music, drawings, etc. Whereas a trademark, the primary function is that it distinguishes one service, one product from another. Going back to our table, therefore, trademarks on AI-generated names and logos, you can register it both in the US and the EU for the simple reason that it's not a creative work. It is just something that sets one product or service apart from another. AI-generated brand elements can be registered so long as they identify the source of the goods and services, their distinctiveness, and meet all normal trademark criteria used in commerce, non-generic, non-deceptive. There's no rule excluding AI in its origin. When we speak to trademarks, we are no longer talking about how it was created. Primary concern of the registering office if it's distinct, if it is not descriptive, it is not deceptive, and whatever other criteria may occur. Now, to give you an example of the considerations taken in when trademarking a brand identity, let's look at what I did when I went through the trademark process for my company name. So if you're in the US or North America, a fizzy drink, think of it as a soda or pop or sparkling water. If my company or if my product would have been, just standard, imagine a can of, doesn't look much like a can, but can of some kind of a soda, and I wrote fizzy drink, it might not have passed the check on, or it might have failed at the generic test because I'm literally explaining the product. But because of the fact that I'm not using it to describe a fizzy drink, literally I'm using it as a service for non-food related services and other products, then it passed that check. If I had, let's say, used AI to come up with this name, it still passed the generic test, it was not deceptive, or it didn't exist already, or someone was not using it, then it still would have been registered and I would be able to use it. So AI has no bearing whatsoever on whether you can trademark something. It just has to pass the other checks that we spoke about, such as it's used in commerce, it's non-generic, it's non-deceptive. So in this case, AI can 100% be used to create a trademark as long as it follows the rules of whatever patent or trademark office you are registering to. The risk, of course, is, I guess this would be further down the line. Okay, that would be infringing on the outputs. Since AI is, of course, trained on existing works by humans, if you don't have something that is sufficiently original when you come up with your brand and you try to trademark it, it might fail the check of similarity, or it could be refused on that ground. Of course, this can occur even if you created the logo or the identity yourself, but these are the risks, right? If you don't know how to look up the logo or the image or the name that the AI generated and you go ahead with trying to file for a trademark, then of course you might run into where that trademark will be refused. That's why it's important when you are doing trademark work that you first start doing searches to see if the name already exists or the image has already been registered. One website you can use is called TMView. As part of the EU IPO, it will also search international databases, the USPTO, Worldwide, etc. And one quick recap here from Harper James' article: can AI-generated brand names, slogans, or logos be registered as trademarks? So there's nothing to prevent AI-generated words, images, slogans from being registered as trademarks, provided that the trademark is distinctive, not simply descriptive in respect to your business's goods and services, and does not contain offensive or misleading content. Then it should pass the examination process for trademark registration application. This is not to say that such trademarks will definitely be registrable, right? There's no guarantee that a trademark generated by Gen AI will not infringe the rights of other brand owners or create a mark that is not already in use by another business. Of course, this applies to human-generated marks as well. Now that we've looked at how you can potentially copyright your AI-generated or trademark your AI-generated content, is it a good idea to actually use generated content? So I'm going to look at two ways and two specific places where it might be a good idea. The first one is going to be in the context of copyright, in other words, content that we want to use for ourselves. And then in the context of trademark. Of course, we've all seen stock images that people tend to use on websites. You have places such as Envato Elements or places such as Shutterstock. In my opinion, this is probably the main reason or the primary reason why you might use generated AI content. The reason is simple. I've done a search, happy corporate team success, the most bland, generic possible type of stock photography that you see plastered everywhere. It's obviously not possible for every company to hire out a photography studio, hire out actors, or maybe just have a film crew come in and take photos of either the company itself or potentially actors that make that content unique. Of course, if you do that, you will own the copyright to, in this case, office work. In your case, it might be your corporate headquarters, it might be your equipment, or your people doing what it is that they do as a company. That will give you 100% copyright exclusivity on the images or the videos that you generate through the production studio. It also means that it's your copyright, you own exclusively the rights to that content, and it's going to be unique to your company and to your services. For a large number of companies who don't have the budget or the know-how, this is simply not feasible. That's where stock photography or stock animation and music sites come in handy. What you get when you have a membership to one of these sites, or you pay for a single photo, is you get a license for a non-exclusive limited use of the photos in question. You're not actually buying the copyright or the exclusivity of any of these pictures. So you, along with hundreds if not thousands of other people, will be using the exact same photos from all of these websites. There will be no uniqueness or distinctiveness between them. To go ahead and have the exclusive rights rights would mean that you would have paid a large sum of money for a specific picture and it wouldn't be able to be used by anybody else. In this case, this is where generated AI comes in handy because it is the perfect use case. I've generated this image right here. Same tagline, happy corporate team success, and of course you will notice that it looks exactly like the other photos because it was probably more than likely trained on a large number of stock photography. In this case, there's no difference or no downside to using a generated AI image like this one, as long as of course you take care that the hands have the normal amount of fingers and that there's nothing horrifically wrong with the photo. But in this case, since you're not able to have a unique image anyway, whether you use this image, whether you have the copyright for it is irrelevant because you will not have the copyright for any of these images either and you're going to be using them anyway. When you need generic low-cost images or perhaps some non-critical music or video animation for a background and the AI can generate it successfully, this is probably the perfect use case at the moment for using generated AI content that is copyright free and easy to use. Coming back to our board, so for generic non-original work is perfect. Now let's look at in the context of a trademark. So I prompted the AI to generate a logo with the name Brand X in a contemporary style for use in corporate identity. Is this a good idea? In my opinion, no. Did it do what I asked? It created a logo in a contemporary style. Fair enough. It's got different colors. It wrote the word correctly. But trademark has more to do, and branding has more to do with your company's culture. Again, if you've just started out, there is no difference between this generation and what existed before. Stock vector illustration websites had the same idea. They would have hundreds, if not thousands, of generic logos that all look the same. And since it looks like a logo that looks like all the other vector illustrations from the past and it was potentially trained on that same data, it might fail the originality or the distinctiveness case with a trademark. And then once again, the naming, is it original? Does it exist? In my opinion, a trademark is the one place where you want to let a human, at least at this moment in time, take care of the creative process. Now, this is not to say that human-made logos aren't terrible looking and that there is no trademarks that just don't look good. I mean, it existed. And also, it doesn't mean that names that have been trademarked aren't ridiculous. I mean, just look at an Amazon listing for 100 or 1,000 different generic products that all have these weird made-up names that are all gibberish and consonant. They do exist, and those were conceivably human generated. So human work doesn't necessarily speak to good quality work. I mean, you can trademark crap, if you will, just as much as you can trademark good work. But if you're serious about your brand identity and your trademark, really you shouldn't leave it up to AI or be low quality human work. So going back to in the context of trademark, should you? No. This, I still believe, is at this moment in time still very much a human endeavor, and you should be looking at doing this preferably from somebody that knows A, what they're doing, and B, can navigate the entire registration process. If you found this video useful, I want you to go ahead and share it with somebody you think might like it. Leave a comment down below and give it a thumbs up.